Got it. Hello, good evening, everyone. We are here today in an association with KelpHR and ILA, to understand digital safety and sexual harassment at workplace. So we have our esteemed panelists, Tanveer and Ashwin here, to elaborate and discuss on the same with us. You, Amrita, if you want to start any introduction.
Yeah, so hello guys, my name is Amrita. I'm from Indian Lawyers Association. Indian Lawyers Association is a legal professional platform which provides every legal professional in India support and provides legal knowledge. Currently, ILA is present in 75 plus cities in India and is looking forward to capture all the cities. So over to you, Meenakshi.
Thank you, Amrita. I am going to introduce myself, and then I'll let the panelists also introduce themselves after giving a brief introduction of them. And today we are going to initially go through the comments that we have and go through some questions around the topic. And then we are going to, towards the end, open the platform for audience questions. So I am Meenakshi. I am a lawyer working with KelpHR and a subject matter in PoSH, and a subject matter expert in PoSH. So we have here with us two advocates who are Ashwin and Tanveer. Both of them come from a rich litigation experience. And Tanveer has criminal law experience, and Ashwin has a lot of corporate experience as well as criminal understanding sexual harassment cases as well. So over to you both as well to introduce yourselves, and if there is anything that you would like to add to the panel. You can start with Ashwin.
Hello, everyone. My name is Ashwin Thool. I have been practicing since past almost 7 to 18 years now. When I was studying, I was with Mr. Satish Manashinde. When I cleared my law, I started working with AZBN Partners. I was with Zia for around 2 to 3 years. Then I was with Mr. Pesi Modi, senior counsel on the original side. My practice predominantly is on the white collar crime side, and I too cater to a lot of corporates. Today's subject, being a very relevant and an important subject, is something that I have dealt with on several occasions. And I feel that this is a very welcome initiative, and more of such wider initiatives required to be taken up. And we can get started after Tanveer makes his introduction.
Tanveer, you are on mute.
Yes. Good evening. I'm Tanveer Khan. I have been practicing as an advocate since 2014, predominantly in the Bombay High Court, but I've also appeared in other courts. And I primarily practiced on the criminal side. I used to work with senior advocate Mr. Ashok Muddargi. I have worked with ALMT Legal also, handling their white collar disputes as well as a bit of civil litigation. And I assist Advocate Sriram Shirsak, who's a union panel counsel, and he represents Enforcement Directorate, CBI, NCB. So I have been assisting in a lot of prosecutions under the NDPS Act, under the PMLA Act, as well as several white collar crimes. I've also represented individuals in cases pertaining to sexual offenses, bodily offenses, as well as white collar crimes in the course of my career.
Thank you, Ashwin and Tanveer, for your wonderful introductions. Actually, I'm very excited to hear on what's going to come out of this panel more than anyone else right now. So, to quickly explore the topic as an introduction, I would like to set the context where we are currently in a era where digital and physical has really diluted each other, and our works are online, our works are offline, we have work from home, we have hybrid models, we also have a digital interaction between each other, and with an influx of a generation that has grown up with digital understanding, and a generation that is also looking forward with like so much tech savviness, that now a lot of shift has gone to digital media, and hence it also is a can of worms that opens various new interpretations on how sexual harassment or cultural boundaries can be dilated, and sometimes these variations of cultures through which we come from, especially in a country like India, it can get really, really tricky to navigate digital spaces and workspaces. So, to start with, I would like to pose a question to Tanveer on how does I mean, I think let's start with the basic question of how do you think the remote work has impacted the dynamics of workplace interactions, particularly concerning the digital communication aspect of it. And then we can go with however the flow takes us. Over to you.
Yeah, so nowadays, especially in the post-COVID world, many organizations have gone digital. Many people are working remotely. They are working from cities that are, different from where their offices are located. Someone is living in Goa and working from there. The office could be located in a city like Pune, Mumbai. So there is a lot of concern regarding the tools that are used for conducting business online. We have Zoom, for example, G Talks, but when it comes to formal meetings, etc., I'm sure there are plenty of other softwares and tools that are used to ensure data protection as well as to maintain the course of the proceedings that take place online. So what happens is that your conduct is very important. You are dealing with your colleagues, you are dealing with bosses who are located all over the world, who are in another place. So that formalness has to be there. That's what I think. And nowadays, since main meetings, AGMs, a lot of big board meetings are also done online, it is very important to set the guidelines in place regarding online meetings. What I mean by that is the dress code has to be appropriate, number one. Number two, there have to be in your policies, etc. You should frame rules which say that you shouldn't share your personal social media handles over there. The images or anything background should be absolutely clean. No sort of objectionable emojis should be used on any digital platforms, meeting platforms or otherwise, and so on and so forth. Now, before, in a pre-COVID world, what used to happen was most of us used to attend offices. Digital meetings, etc., were done only if the parties were located in different countries. If suppose the companies higher ups from America wanted to discuss something with you, they would do it on Zoom, etc., or whatever software that existed back then. But after the pandemic, since everything has moved online, we must also look into the definition of workplace that is there in the Sexual Harassment of Women at Workplace Act of 2013. And if you look at Section 2O, it is an inclusive definition and not an exhaustive one. So it starts by saying that workplace includes. Now, this legislation was, of course, drafted much before the pandemic, but they had contemplated a situation in which a workplace could have become sort of remote, and they wanted to include every kind of workplace where harassment can take place, whether it is in the office itself or otherwise. because even employee under the act does not only cover employees, it covers other people, any other woman uh, with whom harassment has been committed at the workplace. Could be a daily wage earner or a maid, etc. So keeping that in mind, I mean, the dynamics have expanded, and some judgments have also been given by the Bombay High Court and Delhi High Court, which I will share later on in the chat, which have again said that a workplace is not only, it's not limited to the office, it covers places beyond the office as well, where the work is being done. So having said that, a lot of protocols have to be considered when you're conducting business online. Some I have already mentioned, and the others could be like when you file a complaint, if in a remote setup, if there is an allegation of harassment, there has to be a mechanism for which a complaint can be filed. And the proceedings before the ICC can be conducted online, especially if the parties are located in different cities, etc. That these things can be definitely implemented whenever new employees join the workforce. Training and awareness programs can be conducted online again. And for the victim's safeguard, the victim can, of course, take screenshots and record any sort of lewd activity or any sort of harassment that took place, so that the concerned evidence can be led before the ICC and before the appellate authority if it goes in appeal later on. Now, with regard to this, certain other protocols have to be followed. For example, if we talk about digital evidence, there is always the question of compliance with 65B of the Evidence Act, and expert witnesses, expert evidence, opinions from experts are also sought. So all those basics, if people are sensitized about, I think that would go a long way in ensuring that the culprit is prosecuted properly and that the crime does not go unaddressed or the case does not fall flat because of lack of evidence and all that. So these things in the training, these topics should be implemented. Companies or firms can call lawyers or call some legal experts for giving lectures about digital evidence, at least the basics, and to make sure that people are protected, because the stricter you make this, the less chance there is of any harassment that can take place. So yes, to begin with, I would say that we can provide a secure virtual workplace and implement all these certain measures. Of course, there may be more, which the participants can also at the end of the talk ask us, and they can discuss all those things with us as well. The second aspect that I would like to go on to is that harassment in some countries. So, for example, there are some judgments given by the American and Canadian Supreme Courts, which also cover gender-based humiliation as sexual harassment. Although in such cases, for example, if someone tells that you're a woman, you're good for nothing, and courts in US, the Supreme Court of USA has held that that is also, that amounts to sexual harassment, although there was no sexual overtone involved. So when you frame a sexual harassment policy, of course, you can include the gender neutral aspect as well in your policy, as well as you should, I feel, as a company or an entity, include the virtual workplace, include that aspect as well. That workplace does not only limit itself to the physical brick and mortar office, but also covers any place where the business is being done, from where the employees or other workers, interns, etc., where they are joining. Could be their homes, could be anywhere else, a co-working space or anything. Yeah.
Right. Um, Thank you for that. And I would like to pose a question to Ashwin to begin with on what he feels about how to practice digital safety in the first place. What is it that what is digital safety? How are we practicing it in the first place? And how do you think this is translating into the workplace, the beyond workplace definition, the beyond the physical workplace definition that Tanveer has so clearly explained through the legislative understanding of it all? So over to you, Ashwin.
Yeah. So before I actually address that question, I think there are two, three things which I would like to just highlight to the, to start with. Um, Look, there are two sides to this whole PoSH approach. Okay. One is covered under the Indian Penal Code, and the other is covered under the Prevention of Sexual Harassment at Workplace Act, right? One, of course, criminalizes the act itself, and the other gives certain civil remedies to the organization to address issues which arise out of sexual harassment at workplace. Now, there are two fine differences or differentiations that I would like to highlight at the outset. One is that if you look at the Indian Penal Code, I think the manner in which that has been approached, predominantly, it has been the section is now 354 D, if I'm not wrong, and if sorry 354A. The original 354 is outraging the modesty of a woman. Now, outraging the modesty of a woman, when that particular section has been visited by the Supreme Court, it has predominantly highlighted the mind of the predator. And it has, one of the mandates that it has laid out is that there has to be a lascivious nature or an attack by the predator. And therefore, when you look at the definition under 354A and the Indian Penal Code, if one has to follow that Supreme Court mandate and way go forward, I think one of the crucial ingredients would be the lasciviousness of that predator. And therefore, if you look at the manner in which the definition has been laid out, which originally fell from the Visakha guidelines, of course, that there's a physical contact, advancement involving unwelcome and explicit sexual overtures and all those things. Of course, there's a similar definition which falls within the PoSH Act. But if you look at the PoSH Act, in my view, if you start by reading the statements of objection reasons, I think it seeks to transcend beyond this. When it talks about sexual harassment, it seeks to transcend beyond the lasciviousness which is predominantly covered by the Indian Penal Code. I think what the PoSH Act strives to do over here is that it tries to not only give the organization a platform or a mechanism to deal where there are lewd or lascivious a type of attacks on women, but also try and bring in an environment which enables a environment as contemplated under Article 14 of the Constitution, gender equality. So if there is any bias on the basis of gender, irrespective of it being lascivious, it would still fall within the PoSH Act, is one of the first points that I would like to highlight. Now, of course, if you ask me how this digital transformation or how the digital workplace now needs to be addressed and things like those, I think it's a massively evolving space. I think, I personally feel that we will come to the digital space in a moment, but even in a physical space, I think there's a lot of work to be done. I think the kind of awareness which requires is still very far away. It was 1997 when Visakha first laid this down, and then it took, I don't know what, so many years for 2013 for the PoSH Act to come into play. So it took so many years only just the PoSH Act to come, then the ICCs to be formed, then the awareness programs to start. There are several government and local organizations where I feel even as we speak, there are the ICC is still missing, the internal complaints committee is still missing. Leave aside the whole awareness program. So I think what to start with is required is a very, very robust and an aggressive program by almost every organization to sensitize every employee in relation to the sexual harassment related, gender equality related issues at workplace. I think there is that, often arguments are raised that, there are cultural differences and people come from different parts of the country and different parts of different heritages, and therefore their understanding might be different in the others. But I think before the organization starts taking people in, I think a blank a even platform needs to be laid forward, saying that, listen, no matter where you come from, this is the protocol that we follow. We will not observe, or we will not take heed to any other such excuse that you give of your background, if you do not follow these mandated requirements. And there should be, to a large extent, a zero tolerance policy towards it. Now, what has happened in this whole digital area is that, just generally speaking, I personally feel that when you are talking about sexual harassment at workplace, although I highlighted that there needs to be a massive step taken, or steps to be taken towards um, gender equality, or for bringing women in the mainstream. I think at the same time it is equally important that sexual harassment is, to that extent, should also be gender neutral when you are talking about an organization. So today it cannot be ruled out that a man can be equally harassed as a woman, right? Of course, there is no mechanism for a man or a person from an LGBT community to be also being to be harassed at a workplace. But what the mechanism as of today provides under the law is only for women. So what the organizations need to do is that they need to also bring in a mechanism which caters across the board. I think there need to be more sensitive areas when it comes to women and for the LGBT transgender community, because I think that is also the need of the hour. What has happened due to the digital spaces, one of the first things that has happened, irrespective of gender, is that the access of the employer to an employee's time has gone completely haywire. We have heard of times where people leave at 5 o'clock or 6 o'clock and they are back home with in their personal space, got nothing to do with the workspace anymore. Due to this digital transformation, what has now happened is that we are now hearing of con calls being taken at 10 o'clock in the night. I think somewhere that needs to be addressed very, very urgently. And if at all it is very urgent to take up such a call, then I think to that extent there should be certain protocol, whether uh, the a lady should be also disturbed at that hour. If the lady is to be disturbed, then there should be a certain protocol which should be followed, which should be put in place. Of course, there is also an aspect of trans country. So, for example, we are sitting here, somebody is in the US, and because of which it's morning over there and it's evening over here, because of which you may have to uh, take a call at a time which may not be during our regular or usual work hours. But then, therefore, there needs to be a policy in place which sees to it that it is sensitive to the requirements of the law of the land, that is, that of our country, and that the people overseas are also generally sensitized about it. Um, and I completely agree with Tanveer that yes, there should be certain protocols put in place as to from where the calls are to be taken, what should be the background, what should not be the background, more importantly than what should be, and which have to be followed in a scrupulous manner. So I think. Uh, then there is one more aspect that I would like to highlight, and that one is, of course, we are talking about organizations. Then there are also these spaces where there are platforms which are offering people uh, the a there are apps which are offering people platforms to conduct their business or become entrepreneurs from their own space, and this has at the same time opened a massive Pandora's box. If you see, uh, if anybody tries to open something online, there is a lot of stalking that happens. There is a lot of bad mouthing that happens. There is a lot of online attacking that happens, trolling as they call it, and which makes it sometimes very, very toxic. And what happens is, because there is no real filter as to who can come, and there's a lot of invisibility as to who's the person who's actually the user of the handle, it gives that person enough liberty or impetus to misbehave with anybody and everybody at that workplace. So I think to that extent, the platforms also need to, or the organizations need to come together and make a resolution that the platform should allow only verified or people uh, who have given their adequate checks and balances about their identity and where they belong from, to be brought onto the platform, so that this kind of invisible traffic or untraced traffic, which usually misbehave online, can also be filtered away. I think these are some of my starting points. I can take your next question and go forward.
Right.
Just to add to what Ashwin said, that especially that he was talking about making this other late working hours and calling people at 11 o'clock. And sometimes, there may be instances wherein a woman employee is called at wee hours, like at midnight or something, for no rhyme or reason. Now, that can also be constituted or construed as an act of sexual harassment, because the definition of sexual harassment is inclusive. Again, it is not exhaustive. It says sexual harassment includes. And then the Vishaka guidelines are mentioned over there. But if you're calling someone at midnight for a conference for no rhyme or reason, there's no other team member joining, and you're insisting upon that person to switch on the camera, that I feel is a very serious issue. And that should be, mentioned in the policy, and they should say that that amounts to sexual harassment. That's what I think. Because as in the case of being gender neutral also, certain courts have held that it is not only sexual conduct or anything of a sexual nature that constitutes workplace harassment. Even gender discrimination could be workplace harassment. So this, I think, calling people at odd hours should also be included in policies.
Absolutely. I totally agree with both the panelists on this. And I also wanted to add that some it is also based on the impact and not the intent in PoSH Act. And even though it is something that is said that it's a dicey field for us to navigate sometimes, but it's also like how much is the respondent willing to understand and acknowledge that even if they probably did not realize that this is causing some kind of discomfort to the woman that they are working with, they also need to be, or the person they are working with, they also need to be able to take the accountability and understand that, okay, if I am a boss who wants my colleagues to be on a video for 24/7, and even at 11 p.m., I will be like, be on video. Maybe because I am very monitoring about the work, but it does have a sexual impact on people where they are feeling uncomfortable switching on the videos at odd hours for no reason whatsoever. So at
Yeah, I
that
think
point, I think,
this. Yeah, you're right that there is these kind of situations are very fluid. There is no real there is no real straight jacket to this, right? So therefore, I think therefore that's why I started by saying that there needs to be a set protocol that an organization needs to adopt. That if there are certain calls which are to be taken, which basically include or factor in all these ifs and buts. Because when you're actually working and if there is something urgent and as if there's something overseas and on, then there are, some certain situations are unavoidable. But then in those unavoidable circumstances, what are the protocols that you have to follow? That I think, that needs to be evolved by every organization depending upon what is the kind of nature of work that they do, and accordingly, implement it.
On that point, I also wanted to pose a question on how, because technology is also something that we consider a boon and a bane. It has brought in ease. It has actually brought in accessibility for women to take up work. When work from home started and remote work started, a lot of women who were not able to join the workforce suddenly felt that they could join the workforce, because maintaining a work life balance while managing households was way easier. And also people with disabilities could access workplaces with more ease, without the requirement of actually coming into an office. So while technology has acted as a boon for us, I also wanted to ask if how are we using technology only to leverage and benefit the PoSH policies or anti-sexual harassment policies at workplaces. I do have some comments like, even like using, for example, apps like Slack or Signal has also proven to be quite effective in some of the workplaces. So I would like to pose this question to both the panelists. Maybe whoever wants to take it up and start, and then the other person can also elaborate on.
Tanveer, why don't you take it up? Because honestly, I didn't quite follow the question.
Okay. So when it comes to technology and the way technology can play a role in preventing sexual harassment or providing a more safe workplace, as I already mentioned earlier, firstly, of course, the rules have to be put in place as to no sharing of emojis, or the background should be clean, the people should be dressed well. But now, for example, this meeting is going live, it is being recorded. Recording meetings is a good way to ensure safety, because then you have evidence of whatever transpired. You can use those recordings later on in proceedings. So recording is one thing. The second thing more or less pertains to the accessibility, passwords, etc. So only the concerned people can join. It has to be completely secure. So no intruder comes in, it can't be hacked. But now I think nowadays a lot of these softwares are safe. They are foolproof to a great extent, I would say. The other thing is that you should not, as an employee, share your personal social media handles, and even if you want to, depending on the nature of work, maybe sometimes you have to do it. Make sure that your business social media account is different from your personal one. Your personal accounts on Instagram or Facebook should always be locked. There are many people who have their digital marketing agencies, for example. They have a separate page for the business, a separate account where their personal photos are not put at all. It's only the photos of the products and the videos concerning the business that are there. So those things are, that if you can make two separate accounts, that is one thing. That goes a long way, because now recently everyone must have been following the news and what happened to Rashmika Mandana, the upcoming actor, sorry. And that her face was morphed on some journalist's body with the use of AI, and that was misused, and it went viral. So, such things can be avoided if a lot of your personal photos or videos are restricted to an audience that you trust, your friends, family, or whoever that is there. Recording is a great thing that can be implemented. And of course, the proceedings can be conducted online, sexual harassment, the ICC proceedings, etc. Since people are working from home, those things, there can be a mechanism for conducting all those proceedings online. And then the other thing that I would like to say, it's more of technology than law. So this is a question that is best asked to software engineers, etc., as to how you make a software foolproof enough so that no such acts take place, and the meeting software is as formal as possible, so that no emojis, unnecessary things are there that can, you can't send someone a heart or a kiss emoji or something like that. A thumbs up can be used, or the clap can be used, or some of those emojis should only exist on the app. So there's no chance of anyone using anything else. So the software vendors, I think they can create something which is specifically designed for the workplace. So even the backgrounds are not, they don't comprise of cartoons or anything objectionable or something like that. Yeah, this is more of a Meenakshi, I think, more than a legal issue. This is a technological issue. This is more to do with safety and yeah, data protection, all those things.
Definitely. And while we're talking about data protection, a lot of case handling and PoSH trainings are also conducted online.
Online. Yeah.
So what do you think? How do you think this can be more effective, or are there any tips or any
See, again, online, when these training sessions, as I mentioned in the beginning of my talk, that they have to sensitize the employees, the interns, etc., about how to use the platform, what not to put over there, what not, what the kind of language you're supposed to use. And of course, they should be informed that all these meetings are going to be recorded. They must also be informed about certain safety measures of regarding exchanging personal WhatsApp numbers, phone numbers, etc. They should be well precautioned, I think, in the training sessions. And the training sessions, of course, nowadays it's best to conduct them online in a hybrid setup with, in situations where the employees are working remotely from other cities and towns. So these things, it's again, you have to teach them online how to use the meeting, have a mock meeting or something like that. Show what language cannot be used, what things are not to be done, what is permissible. Because if this is done online, the training is done online, then people will be more comfortable with using these softwares later on. Once they have to attend the real meetings, they won't have much of a problem. So I think you can bring again, you could bring a tech expert on board when you're conducting the training session. Let the tech expert talk about these things. Show other managers also how to conduct the meetings, how to share the links, how to make the passwords, make them protected so that no one else joins. And to ensure that the people, the employees, the concerned people are joining and there is no proxy or someone else who is joining, something is not leaked out. Some measures can be taken as to ascertaining the identity of the person who's at the other end. Because sometimes, people may not switch on their videos. They may say that something is wrong with my camera or something, but how do you know it is actually that person who's at the other end? And if that person whose video is not on does something stupid to someone else, and then you find out, and then the real person may say, no, I was not there, there was someone else who joined, and so those things have to be looked into. In session, all these things have to be discussed.
See, sorry, just to
Yeah,
add to, just to add to what Tanveer has just said, I think what has happened with the flux of this digital space is that the bond that an employer and employee, or the bond that the colleagues that used to have amongst themselves, has to that extent evaporated, right? Uh, and therefore it becomes to that extent a little difficult for the employee to open up immediately. You see, for example, if I have a bond with my HR, okay, the moment I sense something, okay, and if I have that comfort, I will immediately raise it. I'll raise that alarm. I'll go up to the person, things like that. Uh, what has happened is because of these online things, because there is no human contact as such, other than just being, technologically being present everywhere. That human contact has evaporated, as I said, and that has kind of made a distance or grown a distance between the employer and the employee, as well as the HR and its employees. And therefore I think what is what should also be factored in, I think, although a lot of spaces have gone digital, I think it is equally important to time and again have certain interactions which are offline, which enables the employer to come in actual contact and do some kind of bonding exercises with with their employers and the between the employers and the employees. um, uh, you see, because that is irreplaceable. Like, for example, we as lawyers, uh, when we were offered when we are offered a digital space, we still prefer to go personally in the court and argue it out, because the mood of the court, the tension between the argument, between the two parts, that physical space can never be replaced. And that bond or whatever that you create when you're there in a physical space is something that we have not yet been able to garner on the digital space side. It will happen over a period of time. Of course, it will happen, but it is still not there. And I think that is what is the same thing when it comes to the this side also. And therefore, I think it is important for organizations to see to it that you can have that you should have more some other than all these online training sessions and all like sexual harassment sessions. There should be exercises to see to it that there is a bond built between the employee, the HR, and things like that, so that the moment there is any harassment, which you have spoken of every now and then, or which you have been very active in making your employees aware about, does transpire, it is immediately brought to the attention and of the concerned authority, and the concerned authority immediately then starts taking an action or collecting whatever this thing. Because one of the biggest challenges that we have found, and we do find as we speak, is that for the victim to speak up, and for that victim to speak up, you have to create a conducive environment. And for that conducive environment, I personally feel that more than a digital space is required. So, although one can keep having and one should keep having all these online training sessions, there should be more and more interactions. There should be more protocols in place. There should be more apps, as Tanveer rightly said, because of these apps that we have available, there is a digital footprint of almost every action that you do online that is now available, and organizations have seen to it that there are backups and all sorts that is required, and that has in fact helped in coming to a conclusion, or to the any ICC when they are investigating any of these. But beyond this, I think, being humans, we need to interact as humans beyond these machines, and that is what will maybe just also help them voice out their concerns.
Yes,
Right.
absolutely. I agree. I agree with Ashwin, because when you are face to face, there is a different sort of bond that is connected because of all the non-verbal communication that happens, the body language, etc., which is more important.
Yeah.
Again, to understand each other's teammates better, understand the organization, understand your bosses, your subordinates, and once in a while, I think an in-person meeting is required. So organizations that
Yeah.
have this hybrid model, once a week people come to the office, another 4 days they are at home. I think that is okay.
Yeah.
That
Correct.
goes a
Also,
long.
they have retreats and all happening for their employees. Law firms have it. Organizations have these retreats where they ask their teams to take their teams out for more interaction, personal interaction amongst themselves.
Definitely, yes,
Those
yes,
kind of things are required.
absolutely,
On
absolutely.
that point, I also would like to add that while it is ideal to be able to interact physically, sometimes it is not possible for
Mhm.
Of course,
companies.
wherever it is possible.
Definitely, sometimes. So, in such case scenarios, I'm also thinking how can there be like at KelpHR, we regularly do online sessions with the kind of understanding where people are building team building practices within the online realm. How the interaction can go beyond just work and people can bond. And I was also wondering if we can get some knowledge from both of you all on a post case scenario. Like right now, we are talking about a preventive measure, but what if something has happened in a completely remote environment? What are the tips that key takeaways, like quick key takeaways that you would want to give to companies to create a safe space, safe reporting mechanism for a victim who or a survivor of any kind of sexual harassment that they have faced? And B, what mechanisms should they be using in a digital space to conduct safe hearings if you are doing it online?
So,
There
number
are
one is, huh, Number one, I'd start by saying is that the victim has to keep the records as much as possible. Just take screenshots. If the meetings are recorded, then fantastic. Everyone has a recording of that. If you receive something on the meeting chat, please take screenshots, store as much of the data as possible. Secondly, organizations should have a complaint mechanism in which a person who's working in a remote area can file the complaint online. So it could be an online form or something that is there, which everyone has access to. The ICC proceedings also can be conducted online. There is no harm in that. There is no bar against it. These things can be done to ensure that the proceedings are complete and they've been carried out in a proper way. All the members of the ICC can join in, and Chapter 4 of the Act, from Section 9 onwards, whatever's from filing of the complaint to the adjudication, everything can happen. It's only that at the time of the appeal, they will have to go to the appellate authority. But that is also taken care of depending where the headquarters of the company are located and where the head offices are. On that basis, that particular appellate authority might have the jurisdiction. Before that, yes, a complaint form which is easily accessible so that anyone who's sitting 500 kilometers away can fill that form with all the details, can send the evidence through a Google Drive or email, as the case may be. And the proceedings also should be conducted online so that witnesses and other people, the victim, the accused, the person who is against whom the complaint has been filed, they can all attend the proceedings online and justice can be done. I feel, yeah, that's a good starting.
Just to add to that, I think, as I said earlier, that because there is a digital footprint that is now available for almost everything that you do online, I think what the organizations can also start with is that they can um they can have a mechanism where they are firstly storing the data or the digital footprint for a certain period of time.
Yeah.
And I'll tell you where I'm coming from. As Tanveer said that once the victim raises a complaint, she should immediately start collecting the evidence and things like those. I think in addition to that, because not every victim may be that savvy or may not necessarily have the know-how. I think if there is, as I said, the data that is stored for some time by the organ, because all these apps, when an organization is asking you to come online, they're giving you laptops, they're giving you apps, they're giving you extra all the wherewithal to actually conduct this work online. So they should, I think to some extent the onus is also upon them to see to it that there is that kind of that kind of mechanism which stores it, so that when a complaint is raised, the first thing that the organization can do is enable the victim in collecting that evidence which is available in their database. And I think for that, I think, as I said, many times we see that the complaints are not correctly drafted or they are not articulated correctly or things like that. I think with this online space, a efficient counselor can actually immediately reach out to the victim, enable the victim to formulate the complaint correctly, understand from the victim as to when, where, how, on what app all the assault has taken place, and post that help the victim or take the proactive initiative in trying to collect that material from the data which is available on the company website. For example, you are recording this particular session, right? You will keep it as an organization. If today something happens, if you retain it for a month, 3 month, or whatever, if somebody raises something about this 2 months down the line, you will be immediately be able to take this particular session out from your database and say, okay, yes, this is what was available with me. This is what happened. I am putting this out also. So it will enable the organization, unless the predator has gone and taken a different route of sending it to her on her personal WhatsApp or something like that. That is when the victim then collects, that particular. But then the
Right.
counselor can help that. Okay, this is where it is. Then this is what you should do. This is what it is. create the evidence and place it before the ICC. So I think because of this online platform, what has happened is efficient counselors can be made available to every victim at any place, and the organization can take an initiative to retain the evidences for some time and make the most of it and take action on it accordingly and immediately. Um, as rightly said by Tanveer, I think online mechanisms for ICC and all are all available. I don't think there is absolutely any hindrance when it comes to that. If courts can go online, then why can't an ICC go online? So there are all those things are available. The burden of proof or the standard of evidence, the quality of evidence is not that high of being beyond reasonable doubt in 65B and all those things. It's not a criminal trial. Even the burden of proof to that extent is a little lower. So in an ICC, if there is anything that is detected to be inappropriate, immediate action can be taken. But the organization also needs to play a slightly more proactive role so that it makes uh, a more fertile place for a woman to come and work at.
It has to be conducive and safe. And a little
Yeah, I agree with Ashwin regarding the counseling part, and someone, if suppose the person cannot articulate it properly, someone can assist that person in making a proper complaint, making sure the allegations are spelled out correctly. That's very important, and I'm glad that you spoke about it. Yeah, and also about again the training and all, telling people what amounts to sexual harassment and how compliments are to be given at the workplace, etc. There is this one small thing I would like to discuss. It's a bit of a gray area, but it is of concern because I have seen a few cases in which this has happened. When there are consensual affairs at the workplace, some sexual relations that are consensual. Now, I personally am a little orthodox in this regard. I'm completely against the concept of workplace romance, but it happens, and in some big firms and all, because they spend 18 hours, 15 hours at the workplace, they don't really bother about such things. But I feel that in the policy, the romance at the workplace should be considered as sexual harassment. I don't, because it can lead to a lot of bigger problems that will affect the productivity of employees and for the goals of the organization. So yeah, that is of course a gray area because number one, it's consensual. Number two, it is not really, in my opinion, appropriate to the workplace. So that consensual relationship, that topic also, I think, has to
You're
be looked.
intruding into their
like I
personal
think,
space. But I quite see what happens because of that is a favor. Maybe one may be favored over the other. If one is a colleague and then, but yeah, but other than that, I think it's a personal space as long as
Yeah, of
it's
course, this is
with
personal,
consent.
not personal. I think because it's regarding two people from the same organization being involved, then that does lead to problems. And then when things go south in the future, one files the complaint, and then again there are other issues. Things get
It's a
complicated. That
topic
has
for another
happened.
time.
Yeah,
yeah, it is a next ILA session. We'll probably
yeah,
pick up
actually.
sexual relationships because we have a lot of opinions on it. Every person has a different opinion on it. Every company has either a consensual relationship policy that allows it with certain regulations or it does not allow. We'll get into it. But before we get into all these plugs, I would like to also address that there are some raised hands. Some have raised hands since quite some time. Hands must be hurting. So we need
It's
to
digital, so I guess it's all right.
maybe.
Just the
We
hand emoji,
have-
not the physical.
yeah, the hand emoji is hurting right now.
Yeah.
So let us address those. And before we dwell into that, because we were mentioning that we are recording this video, this is also available on YouTube. With KelpHR and ILA does provide these databases for free, and these webinars are there on YouTube for anyone to see later if they've missed out on any point or if they want to refer it to people. That being said, I think we'll start by addressing the raised hands. Professor N. Venkateshwarlu, you have had your hand raised for quite some time. Please, we'll start with you. Could you please unmute yourself and
Mr. Venkateshwarlu, your hand has been raised. Can you hear us? can unmute yourself and answer, sir.
Or just type your question in the chat box.
Yeah.
There is one question which she has tried. Can you explain about
separate notice there.
Yes, audible now.
Yes, sir. Yes.
Hello?
Yes,
Yes, sir.
tell us.
Sir, I think your question in English would help.
Meenakshi, we can move on to Mr. Gupta then.
There is a slight problem there. We can go ahead to Mr. Girish, maybe.
Girjesh Gupta, yes.
Girish Gupta, really sorry.
Good afternoon to both the Learned Council. I am Advocate Girjesh Gupta. So basically, my question is on behalf of employer, and I am facing the problem from quite long, last 3-4 years. This is regarding the startups, very young organization who has attained a threshold limit of 10 employees. So basically, this PoSH is applicable to them. But generally, I have faced a problem when they come up to me and they are saying they don't have even a single female employee. So how they will constitute their internal committee, because there must be 50% participants from the female members. So this is the legal question, the question of law, because they want to comply, but the problem, they don't have the female members because they have not deployed any female employee. Like they have 15 employees, 16 employees, all are male members. So in that case, I just want to know, is there any alternate, because the penal provision is quite high, 50,000, including the closure of the business. And I tried many times to, consult with other authorities also, but they have no answer, because this is not even prescribed in law or rules. So sometime I have done from my side, you please draft a policy, but in complaint mechanism, you just write to refer the local committee, which is being chaired by the, a district officer of the district, because you don't have the female employees and you are not willing to deploy senior level of female employees. So this is my query. If I wish if you could help me out, or is there, how can we deal such kind of situations? Thank you. Thank you.
See, if you read section 4 of the Act, Mr. Gupta, section 4, subsection 2, clause A, which says that a presiding officer who shall be a woman, the internal committee shall consist of the following members, be nominated by the employer, namely, a presiding officer who shall be a woman employed at a senior level at workplace among the employees. Provided that in case a senior level woman employee is not available, the presiding officer shall be nominated from other offices or administrative units of the workplace referred to in subsection 1. And then it again, clause B, if you read, it says that not less than 2 members from amongst employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge. And I don't think that there is a requirement as such, mandatory requirement that a woman has to be there. This seems to be, as per my reading of it, that even a man can be on the panel. He can also be the presiding officer if no woman is available. So of course, that is not an excuse for not constituting an internal complaints committee, because anyway, later on, there is an appellate authority, there are remedies available. So you can employ, or you can, make anyone else the presiding officer if no woman is available in the office.
And maybe
secondly, I mean, please.
Member is a woman.
Pardon me?
Sorry, maybe ensure that the external member is a woman if possible.
Yeah, of course. That can, be taken up. Make sure that if, an external woman can be a member. And secondly, what I would suggest, Mr. Gupta, is like, yes, organizations, of course, no offense to you or anyone, but organizations should have a blend of men and women. I mean, this is not Something that an only man organization is now, I mean, it's not appropriate in today's world. I feel that any organization, no matter how small or big it is, should have a diverse, I mean, there should be men, women, people of other genders, whatever. This is just a thought. I mean, yeah, nothing.
Mr. Gupta, firstly, if all employees are women, who would be complaining about the sexual harassment?
Hmm.
Any
Sorry, or if all
female,
are men?
Men.
If all are men,
all are men, then actually what happened? Sometime auditors comes to them, they may be a female and some other
Recruiters can complain, yeah.
stakeholders that the woman can visit. At that
huh,
times there may
I
be
follow.
chances
I
or
follow.
some
I
other
follow. Very
like
good. Very good.
housekeeping
I follow.
staff,
So
security
then, in
staff.
that case, I think, see, Mr. Gupta, I think at the end of the day, more than the letter of the law, the spirit of the law is what is important, right? I think there is enough elbow room in this section 4, as rightly pointed out by Meenakshi as well as Tanveer, for one to include an external member who is a woman. I think the reason for having a woman over there is to see to it that there is a equitable approach, an unbiased approach that is adopted by the ICC, and therefore, as I said, as long as the spirit of the law is upheld, there is no court or no authority which will really come after you or will take aggressive action against you. So therefore, I think first thing, as rightly pointed out by Tanveer, is that there needs to be a policy in place, an ICC policy in place. I think that mechanism over there, the should mandate or should have the provision that in case if there is not, then one of the member of the committee should be taken from an external source, such as an NGO, as maybe KELP, or any of these. So there is enough elbow room in the legislation to do that. And as I said, as long as the spirit of the legislation is upheld, I think the law or the protection will also be upheld. So, to that extent, I think a policy can be formed to see to it that women members of that the members of the ICC do include women in some form or the other from some organization or the other. That elbow room can be kept in your ICC policy. It can be kept flexible enough to have the spirit of the law.
Thank you,
We
sir.
have
Thank you,
one more
Tanveer, sir.
question.
Ashwin,
Thank
sir.
you. Most welcome, Mr. Gupta.
Thank you.
Hope that answers the doubt.
Yeah.
Yeah.
Their advice is always, I will definitely go through and thank you so much.
Thank you. Shankar has a question. They have raised their hand since quite some time.
Mr. Bellari Setti, please unmute yourself. You're on mute. Better.
Yeah. Okay. This external committee member, so the law seems to be very vague around it. A person having passion towards it or working towards the cause or having sufficient knowledge.
You're inaudible, Mr. Shankar. We cannot hear you.
Can't hear me. I'm so sorry. 1 minute, please.
I think we are not able to grasp what Mr. Shankar.
I think it's the same question he has asked on chat. Who is eligible to external committee member and what government certified program can be done to be truly?
Am I?
Now you are audible, sir.
No. Thank you. See, the external committee member, the way the law is defined, and even Meenakshi kindly typed it offline for me, but that somebody who's passionate about the cause, okay, maybe it's an NGO or somebody with the knowledge of that subject,
Yes.
So, but it is not defined who is qualified. See, forming an internal committee but not getting an external committee member is a problem, number one. Number two, if it ever goes into a court, okay, the findings by internal committee could be cancelled because the external member is not competent to be part of that committee. So I wanted some thoughts around this, that who is the person who can be appointed as an external committee member, and how is it validated? For example, they say a lawyer is there, but which lawyer? There are lawyers who specialize in civil, there are lawyers who specialize in criminal. They might not be eligible. Yes, a lawyer who's specializing in PoSH could definitely be available. But however, this applies to organizations with 10 plus employees, and we are talking of so many companies. Its a volume is too large for even NGOs to address. So just trying to understand that legality around this whole thing to ensure that proper external committee member is appointed.
No, I completely agree with you, sir. I think you are absolutely right that there is a massive disconnect between the demand and what is today being offered. And as such, what I have seen usually that the courts, uh, uh, do look at, it's not that if a person is uh, what they look at is what is the kind of work that the person has put in, or from the resume if they have done any kind of work in relation to women in emancipation and things like those. They do, and usually I've seen organizations also try and identify those kind of people who have that kind of contribution in the society to take it up on the panel. But you're right, it is vague, and it has rightly been kept that vague so that it gives the organization the elbow room to identify a person who they feel is appropriate to be brought in, who has the correct mindset to be brought into the committee. And I fully subscribe to what you're saying. I think what really also needs to be done is that there needs to be a platform where trained counselors or people who are well acquainted with these kind of laws or challenges. There should be some kind of a platform where names are available, and more readily, more people, short-term courses should be made available for people to get trained for ICC or things like that, so that organizations can go to these places and have some kind of a certified counselor or certified person to be taken on. I think more certification or certified courses need to be made available so that people do get active. All this forms as an ecosystem to bring in a more aware society about women's rights. So as you're right that as much as there is the mandate to have the to trained people on the ICC committee, at the same time there should be a very conscious effort to see to it that people are trained to be made available for these committees. That will, I think, serve both the purposes of having that awareness about women emancipation, as well as catering to the requirement of the ICC. So it is a disconnect. It will take some time, but I think to a large extent, if some participation in women emancipation is there, the courts are happy to accept those kind of members in the committee.
Wonderful. Thank you. One more, just one add-on thing. We are talking of remote
Mr. Sethi.
workers. Yeah. We are talking of remote workers. Suppose a company is based in Mumbai but has one remote worker in Guwahati. What will be the applicability? Jurisdiction wise, where will it be applicable? Will it suppose something has happened online during a program, something has been said, so it will be jurisdiction would be Guwahati or would it be Mumbai?
So part of the cause of action is arisen on both sides. So what the jurisdiction which will be more convenient for the woman will be the one which will be adopted for taking the proceedings forward. When you're talking about criminal proceedings, in relation to ICC committee, I think it's trans jurisdiction. I think it does not matter where you sit, because the ICC operates over the entire organization wherever they are. But when it comes to a criminal offense, because it's online, part of the cause of action is arisen there, part of the cause of action is arisen over here. Therefore, both places may get jurisdiction, and the one which is more convenient to the victim could be adopted as the appropriate jurisdiction.
Yes.
Thank you, Ashwin. Thank you.
I hope that answers the question. And also sorry that we cannot take any.
Tanveer, you wanted to add something?
Yeah. Mr. Sethi, see, the Act and the rules are silent as to the qualifications of external committee members. And as Ashwin also rightly pointed out, that there could be a panel, there could be some criteria as to, what for being an external committee member. And from the panel, you can take competent people. Now, the problem is that in the law, in the books, there is nothing, there is no criteria that is laid down. Someone in the future, if someone files a PIL, the courts may intervene, as they did in the case of the Arbitration and Conciliation Act. And then the courts may intervene, they may set out some criteria and also direct the government to constitute panels from which external committee members can be selected. Now that I feel the judiciary's intervention is required. But however, that is when someone files a PIL, someone approaches the writ courts and does something.
Thank you. Thank you very much.
But then again, that is left to the wisdom of that organization. And as I said, what is expected is that the spirit of the law is upheld more than anything else, that way. Say, for example, somebody is a panchayat member. Now, that panchayat member may not have had anything actively done, but as a panchayat member, he's done something towards the emancipation of women in his particular village. He can be a member of the ICC if he's closer to that jurisdiction. So, that particular wisdom has been left to that organization. That elbow room has been left to that organization, and I think therefore that vagueness in that language, as long as the spirit of that particular legislation is upheld.
But I hope to uphold the spirit the courts intervene, because then if some criteria is laid down that makes it better and more safe in the future, I think that will be better. The spirit can be upheld. It will be more foolproof. Again, there will be some statutory or some precedent that will back this thing up. So I think, Mr. Sethi, I think in the future, I hope someone initiates something and it works out that way. That will solve a lot of issues.
Maybe you can.
And then no one in the appellate authority can say this person was not competent. They didn't have any experience and all those things. Yeah.
On this note, I'm really sorry, but I think we have to stop the discussion. And thank you for the wonderful participation and the passionate discussion that happened so far. And I hope that we have kept you engaged. And also, if there are any further questions, feel free to reach out to us and write to us. And we will try to address them as much as possible. So to keep this going, thank you, Ashwin, and thank you, Tanveer, for the wonderful discussion. And also, we should take away from this session that the spirit of the law is to be upholded rather than the letter of the law. That is a very key takeaway for me personally from this session. So thank you so much, everyone.
Thank you.
You are most welcome.
Thank you for having us.
Thank you very much. Bye.
Bye.
Thank you.
Goodbye.